The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Thank you, Mr. Sewell. Good morning and welcome to the North Carolina Court of Appeals. My name is John Tyson, and to my right is Judge Toby Hampson, and to my left is Judge Fred Gore. We have one case on the docket for argument today, case number 25181, Griffin versus the North Carolina State Board of Elections and Allison Riggs. Counsel are present, and we would ask that counsel introduce themselves at this time.
Good morning, Your Honor. My name is Craig Schauer. I represent Judge Griffin.
Good morning, Your Honor. Troy Shelton, also for Judge Griffin.
Okay.
Good morning, Your Honor. My name is Nick Brode, appearing for the State Board.
Thank you.
Good morning, Your Honors. Ray Bennett appearing on behalf of Justice Riggs.
All righty. Gentlemen, as preliminary matter, have you decided how you wish to divide your time this morning?
Yes, Your Honor. On behalf of the appellees, we will divide our time 15 minutes each, with Mr. Broad going first.
All right. Are there any, you going to reserve any time for rebuttal?
Defer to the
Appellee. Yes. Thank you.
Your Honor, this is Mr. Schauer on behalf of Judge Griffin. Mr. Shelton and I have divided our argument based on topics. I anticipate that I will use about 15 minutes of our time. Mr. Shelton may use 10 minutes, and then we'd like to reserve 5 minutes for rebuttal. Okay. And when I start my argument, I'll identify the topics that I plan to address and the topics that Mr. Shelton plans to address.
Okay, very good. All right. Okay, is there any other preliminary matters to come before the court before we get started? Okay, at that's time, then we will hear from the appellant.
May it please the court. Again, my name is Craig Schauer. I represent Judge Griffin. My partner Troy Shelton and I will be dividing the argument. I'll address the procedural and constitutional objections raised by the appellants. I'll talk about the incomplete registration protest, as well as the appropriate remedy if Judge Griffin prevails on the protests. Mr. Shelton will be available to answer questions about the never resident protest, the photo identification protest, as well as appellee's time-based defenses such as latches and the Purcel doctrine, and then the England reservation. At bottom, this case is about whether the election was conducted in accord with the will of the people of North Carolina. According to the State Board, it can conduct an election how it wants. It doesn't matter if the board adopts rules that are inconsistent with state statutes or the state constitution, because after an election is over, it's too late to demand that the actual laws be enforced. But the General Assembly has rejected the board's positions. The legislature wants elections to be decided correctly, based on the laws enacted by the people's representatives. Therefore, the legislature created an election protest procedure that allows parties to object to an election that's conducted in violation of the law. Our Supreme Court has also rejected the board's positions. 20 years ago in James v. Bartlett, the Supreme Court upheld an election protest that identified illegal votes. The Supreme Court held that the illegal votes could not be counted. That's because counting illegal votes disenfranchises everybody else who voted legally. James v. Bartlett is binding precedent that this court is obligated to follow. So to be clear, this case is not about changing laws after the election. It's a case about enforcing the laws that were already on the books before the election. Now, knowing that the judges have carefully studied the parties' briefs and arguments, my primary objective is to make myself available to any of the questions the court has. Absent that, I'd be happy to recap Judge Griffin's positions on the procedural and constitutional issues, the incomplete registration protest, and then the remedy before I turn my time over to Mr. Shelton. So to start with the procedural issues, the State Board first tried to dismiss Judge Griffin's protest on procedural grounds.
Well,
the board ruled that Judge Griffin.
Mr. Schauer, can we let's step back a little bit and kind of put this case into context for us. As you have stated the issue in briefing before us, the issue is whether the Superior Court erred in affirming the State Board. which kind of puts this in its procedural context, right? This is effectively judicial review of agency administrative action. Is that fair?
Yes, Your Honor.
And do you agree then that our review is similar to any other agency review case of a Superior Court order sitting as an appellate judge, and that so our duty is to, number one, determine whether the Superior Court applied the correct standard of review, and then two, whether it applied that standard correctly to the board's decision. Is that a fair statement of kind of where we are procedurally in the scope of our review in this case?
Yes, Your Honor. All right. So with that in mind, I'd like to address the legal decisions that the State Board made and the Superior Court upheld, starting with the procedural issue. So the State Board decided to dismiss Judge Griffin's protests on procedural grounds. The board ruled that Judge Griffin had failed to comply with the board's expectation that he serve all affected voters with copies of the protests. Now, as a threshold issue, the board was not authorized to demand that Judge Griffin serve copies of the protests on all affected voters. The board's demand exceeded the rulemaking power that the legislature had given it.
Was that particular argument raised before the State Board that there was no authority to even require service in this case?
Yes, Your Honor, I believe it was. And so what we argued was that based on the statutes that authorize the board to make rules, it authorized the board to create a protest form, and it authorized the board to provide rules that instruct the county boards on giving notice, but it did not authorize the State Board. The General Assembly never authorized the State Board to issue a rule that would compel protesters to serve copies of the protests on individuals affected. That was an obligation that the statutes placed on the county boards. Nevertheless, Judge Griffin tried to comply with the invalid demand, and has substantially complied with what the State Board expected. He mailed over 60,000 voters a postcard that notified them of a protest being filed, that it affected their vote, and that they can contact their board to learn more. The postcard included a QR code that provided a link to copies of the protests that were electronically searchable. So the service provided by the postcard sufficiently complied with the State Board's demand, even though they didn't have the authority to make it, and it also complied with the procedural due process clause. Moving on to the parties' constitutional objections, the board and Justice Reed argued below. Yes,
prior to moving from the procedural standpoint, it appears the decision by the board was procedural and not really a substantive evidentiary hearing. What is your position as far as what more we need before we really could? Is this a case where we need to send this back to the board for a substantive hearing prior to being able to really rule on the merits of the case because they were premature in ruling based upon your argument?
No, Your Honor, I believe that the board resolved the protests on legal issues and not factual issues, and those legal issues are properly before the board. So the question of whether or not the protest was procedurally compliant is a legal question that the board can answer. The question of whether or not the issues raised in the three categories of protests are correct interpretations of the law according to Judge Griffin of the board is a legal question that this panel can answer. The question of what the ultimate result of those legal issues should be would require a remand. So in other words, we are asking that the court adjudicate the correctness or incorrectness is our position of the issues identified by the State Board in its ruling, and then remand it to have an evidentiary hearing that determines the actual number of voters who were not allowed to vote, but nevertheless their votes were counted, and requires them to adjudicate the protests filed consistent with the law and based on the number of voters identified in the law. And then we believe the law, based on James v. Bartlett, requires that those illegal votes not be counted, and that they therefore discount the votes and adjust the vote count and declare a new election result. And so we believe all of those issues are properly before this panel.
Going back to Judge Hampson's earlier question, our review on the issues before us would be de novo. Is that correct?
Yes, Your Honor. The legal issues are de novo review.
Now, is your challenge a facial or as applied challenge or both?
Well, Your Honor, the only constitutional issue that we raise is the never resident protests, and Mr. Sheldon can address whether or not that's a facial or as applied. the incomplete registration protest and the voter ID protest are based solely on constructions of statutes. And so those are not facial as applied challenges.
Okay. Or is your argument the Administrative Procedure Act under Chapter 150 applies to the board's decisions or not?
Yes, Your Honor. So that is the act that governs our review.
Okay, thank you.
So looking at the constitutional issues, the first issue raised by the appellees is the right to vote. Now, the right to vote is not absolute. The North Carolina Supreme Court and the U.S. Supreme Court have made clear that the right to vote is subject to the state's need to protect the integrity of the elections. Therefore, the U.S. Supreme Court has created a balancing test, the Anderson verdict test, to determine whether a restriction on voting violates the Constitution. And the same test has been adopted by the North Carolina Supreme Court. The protests do not violate the Constitution because they do not impose a severe burden on voters. Judge Griffin is asking the court to enforce even-handed laws that ensure only qualified voters are allowed to vote. That is not a severe burden under Anderson verdict.
But how does it not impose a severe burden? I mean, the remedy you're ultimately seeking not impose a severe burden on the right to vote, where petitioner in this case is only challenging certain votes in certain counties. We're not challenging in-person voting. We're challenging only absentee ballots. And particularly, I guess, particularly with the overseas in certain counties. And we're not challenging in-person votes that have allegedly incomplete registrations. So how does it not impose a significant burden on voters all across North Carolina, where we're only selectively looking at certain ballots?
Well, Your Honor, I think the concern that you have identified is best viewed under the Equal Protection Clause versus the severe burden test. And I think your point is that there are certain categories of voters that Judge Griffin identified as having violated the law, but his protests were not able to identify other categories of voters who have also violated the law. And 2 points on that front. First, the Equal Protection Clause is only invoked when the state takes action to discriminate against individuals. It's not invoked when an individual takes action. In other words, Judge Griffin, as a private individual, filing a protest can't violate an individual's rights because he's a private actor.
But the bigger point, though, and I think what we'd hear from your colleagues on the other side, though, is what the petitioner is asking, the remedy the petitioner is asking for the state to impose by discounting these votes is what would constitute the state action that would be violative of equal protection or substantive due process, wherever wherever we draw that line between those two different concepts.
Well, I don't believe this is a principle cited in our cases, but my understanding is that the state action, the question of whether or not there's state action, the U.S. Supreme Court has held that the mere invocation of a state procedure doesn't constitute state action. In other words, a private party can seek a remedy provided through litigation or an administrative remedy, and simply seeking that remedy doesn't qualify as state action. So we still take the position that Judge Griffin's filing these protests doesn't constitute state action that invokes the Equal Protection Clause. But even if the court were to disagree, the protests here challenge certain voters. The simple fact that certain voters were identified as having violated the law, but other voters were not identified as having violated the law doesn't raise an equal protection violation. The Supreme Court held in the Kresge decision, which we cited in our brief, that the fact that one category of people are identified as violating the law doesn't give them a claim that their rights have been violated under the Equal Protection Clause simply because other categories of individuals were not violated, absent evidence of intentional discrimination by the state, which is absent here because the state is simply adjudicating the protests filed by a private individual such as Judge Griffin. So we don't believe there's an equal protection violation here, Your Honor.
Let me ask you this. One of the questions I'm sure we're going to see is whether you are challenging the board's procedure or where you're challenging individual voters. Can you address that issue, whether this is a voter challenge by another voter, or is this a challenge to the procedures of the board, or both?
So it's a challenge filed by a candidate. So the election protest allows both candidates and individual voters to file a protest. All of the protests were filed by Judge Griffin, and we were challenging the lawfulness of individual votes because the state board allowed them to vote in violation of state law. And so it is a challenge against the individual voters' votes, but it's due to the state board allowing them to vote in violation of state law.
So let's talk about the registration issue. I think that's one of the issues you want to address. Can you kind of give us a thumbnail on how the law changed in 2002 with Help America Vote and the North Carolina requirement, and what the board did or did not do in relation to those two laws, the federal and state law?
Yeah, so around 2003 or 2004, the federal government enacted HAVA, which is the Help America Vote Act, which required individuals to provide driver's license and social security numbers as part of registration. That law applies only to federal elections. This is a state election. It doesn't govern this election. Nonetheless, because the state has to operate federal and state elections at the same time, the state passed a parallel law, which is 163.82.4, which also requires individuals seeking to register to vote for all elections, including state elections, to provide a driver's license, or if they don't have one, a social security number. At the time, the state board was not actually requiring individuals to provide that information on applications. In other words, you could complete an application, omit that information, be registered to vote, and the state would let you to vote. That violates the law because 163.82.4 requires that not only the information be provided on the form, but if it's omitted, subsection F requires the state to not allow you to vote if the information is not provided the day before canvass.
Now, what about the registered voters prior to the adoption of those two statutes?
So, Your Honor, the information we received from the state board, we identified individuals who, according to the voter registration record, the official list provided by the state board, had registered before 2004, which is when the law went into effect, and we did not challenge those voters. We only challenged individuals where the data showed that they had registered after 2004, which means that they were obligated to provide that information when they applied for registration.
So any voters who were registered prior to that date, even though they do not have the driver's license or social security number, you're not challenging those at all?
That is correct, Your Honor. We did not identify them in our protest based on the data we received from the state board.
So between 2004 and a intervening lawsuit, what happened as far as the board's efforts to secure that information?
So even though this issue was identified to the state board back, I believe, in the fall of 2023, and they have started to collect this information from individuals who have registered since 2023, they have not attempted to collect the individual information from individuals who registered from 2004 up to 2023. They've allowed them to continue to vote, including in the 2024 election, despite the fact that the information was never provided as required by statute. And that category of people who voted, who were registered between 2004 and 2023 and voted in the election in 2024, that category of people is the people we identified in our election protest.
Now, in terms of residence and registration, you had to be a resident of the state in order to register to vote. Is that correct?
Yes, Your Honor.
Okay, so what is the period of time? Is it a year? Is it 30 days? Or at what point of time is the registration complete in order to vote in the succeeding election?
In terms of residency, Your Honor?
Both on residency and registration.
So in terms of registration, I can't recall when the registration deadline closes in advance of an election. In terms of residency, that is a question for Mr. Shelton, who I think can address that when he talks about the never resident protests, which talks about residency requirements. And so I would ask to defer that question to him.
Okay.
And with that, I've gone over my 15 minutes. I'm happy to answer additional questions about incomplete registration or the remedy, but I also want to make sure Mr. Shelton has time to address any questions on the topics that he's planning to speak on.
Okay, thank you.
So I'll turn it over to Mr. Shelton. Thank you, Your Honors.
Thank you. Mr. Shelton?
Good morning, Your Honors. Troy Shelton for Judge Griffin. I want to turn first to Purcell. Purcell doesn't apply to this case for a host of reasons. First, the argument is squarely foreclosed by the Godfrey doctrine. Under Godfrey, a court can't affirm an agency decision for reasons different than those given by the agency itself. When this court is reviewing agency action, the court is not asking whether the ultimate resolution of the question is right or wrong. Instead, the court is asking something different. It's telling the agency, show me your work because we're grading the explanations that you gave. That's the Godfrey doctrine and the Chenery doctrine as it's applied in federal courts.
But doesn't the board's decision throughout its analysis apply the basic principles that arise from Purcel and an equitable doctrine such as latches, from which Purcel effectively emanates? Even if it doesn't use the word Purcel, it clearly speaks to some of these issues. With respect to unregistered voter or allegedly incomplete registration voters, it talks about latches expressly. And then with respect to the other two categories, it points out that these rules and statutes have been there and available to be challenged for years prior. And there was no challenge. There's been no challenge to the rulemaking authority. There's been no challenge to the statutes that allow, these covered voters to take part in elections. So those principles are all the way through the Board of Elections decision. So why isn't the Purcell doctrine available for us to rely on here?
Your Honor, I'd have to respectfully disagree with that interpretation of the board's decision. When the board is talking about anything that has to do with time, what they're talking about is the substantive due process argument that was raised by the appellees. That's all that was being addressed, and it addresses that, I think, almost exclusively in the incomplete registration voters part of the decision. The word latches does appear in the decision. There's not a determination of latches. I believe the word latches maybe appears in a parenthetical when they're talking about a case that had to do with latches, but there's not a latches determination made, which is unsurprising because the appellees didn't argue latches. I mean, latches is a fact-intensive inquiry. It's a 4-element test. The appellees have never argued a single element of that test. So I don't believe that latches wasn't argued below. It wasn't the basis of the board's decision. But more importantly, when we're talking about Purcell simply can't apply to an election protest remedy that's created by statute. By statute, election protests are filed only after an election is over. That's why no court in the country has ever applied Purcell after an election was concluded. No court has ever applied Purcell to a statutory protest remedy. If the board could use Purcell to essentially abstain from hearing election protests filed after an election, that would invalidate the protest statutes.
But I don't think that's the argument that's being made. I don't think the argument that's being made is that Purcell precludes all election protests. I think what the argument, as I interpret the briefs, and I'll let your colleague speak to this too, is that the types of remedies that you're seeking in this case, which is throwing out the votes of otherwise eligible voters who voted under the rules and regulations and in compliance with those rules and regulations as administered by the board and the state, were valid at the time they were cast. And so the principles of Purcell would say, we don't change the rules now. If you want to challenge it prospectively, that's one thing, but you can't change the rules retroactively to discard the votes of otherwise eligible voters.
Your Honor, our argument is not that you should change the rules today. Our argument is please enforce the rules that exist at the time. And those are the state constitution and the state statutes that existed at the time. I think really what the appellees are after, they're saying these types of challenges are not what count as irregularities in misconduct under the protest statutes. The problem for them is that in 2024, the Supreme Court unanimously held that these are the very types of challenges that do count as irregularities. That was a unanimous decision by the Supreme Court in the Bouvier decision, where the Supreme Court said that green-lighted election challenges for challenging categories of individuals, whole categories, people who are ineligible to vote, including, quote, non-residents, and also, quote, people who are not legally registered to vote. My friends on the other side have simply never responded to the Bouvier argument. It's clear that they disagree with Bouvier, but I mean, the ink is barely dry on that case.
Mr. Shelton, in light of Judge Hampson's question, how do you balance James with Purcell? In light of it seeming that it's a change of the outcome and then Purcell saying not, how do you balance James with Purcell?
Well, I think that Purcell, James is the case that actually controls. James is the case that's an actual election protest. So they're looking at a protest that's filed after an election. Purcell only ever applies before an election. So they're simply two different categories. Now, it's, the legislature could say, well, there's certain types of challenges that have to be brought before an election. There's certain kinds of challenges that have to be brought after the election. That's just not the law in this state. Our legislature, especially in the protest statutes, especially as they've been interpreted in the Bouvier decision, they simply take a different path. The different states could handle those differently if they want to. But the James decision says what's most important is that we get the decision right, the election results right, because when we get them wrong, when we let people vote who shouldn't have been allowed to vote, that disenfranchises all of the legal ballots. And an election protest is allowed to challenge that. I'm sorry.
No, you're fine. There was a difference though in James, and James, part of the issue in James was that the state board had not provided guidance prior to the election that they were actually going to, in fact, count votes, absentee ballots that were cast outside of the proper precinct. And so and if you look at Hendon from the Fourth Circuit and other cases applying these equitable principles, those cases clearly, to me, indicate that the Purcell doctrine may apply, but the exception to the Purcell doctrine is if there was kind of a lack of notice prior to the challenge, prior to the election, that these issues were going to arise. And it seems to me that's exactly what happened in James, right? The Supreme Court said, first of all, you couldn't have brought this challenge earlier because the state board gave no indication that it was going to count these ballots. And the second part of James is that the holding that the state board in that case was in fact acting contrary to the law, statutes, rules, and regulations that were in place at the time. So why does that not harmonize the Purcell principle with the ruling in James?
The problem there is that the challengers essentially could have known exactly what the state board was going to do, because in two primaries in 2004, they had allowed out of precinct voting. And then even when you read the decision, it says one of the challengers, not both of the protesters, but one of the challengers asked the state board and got some equivocal answer from the state board that certainly didn't say that they weren't going to, that they were going to prohibit out of precinct voting. And so what the court did was it said, it's really unfortunate that the state board has allowed, misled these people into voting out of precinct when they weren't allowed to do so. But what we have to do is apply the law, because what the state board did was contrary to the law. And that's the same argument that we're making here, that what the state board did is contrary to the law. I see that I'm into my rebuttal time. I have other points to make, but I also want to be sure that I answer all the court's questions. I'm happy to continue on to never residence or continue talking about Purcell, or to yield the floor to the other side.
I have one question, and we'll try to reserve some rebuttal for you. But can you explain the relationship between Section 20 and 21A and General Statute 163, and can you harmonize those provisions?
Yes, Your Honor. So this goes to the overseas no ID protest. Article 20 sets out all of the general rules about absentee voting. Article 21A then changes many of those general rules for overseas voters. But Article 21A, when you look at it, is not a comprehensive set of statutes. Article 21A necessarily relies on Article 20 for general rules about absentee voting. My friends on the other side actually don't dispute that point. So that is the statutory framework that you're looking at when trying to decide, okay, it's an Article 21A ballot, but what parts of Article 20 apply? And there's a statute that says Article 21A doesn't change anything in Article 20, but of course we're not arguing that. We're saying there are parts of Article 20 that necessarily apply to some ballots cast under Article 21A. Now, my friends on the other side say that some overseas voters have special impediments to voting, so they shouldn't be burdened with a photo ID requirement. But we think that's really unpersuasive, even as a policy argument. Valid photo IDs include passports and military IDs. Military and overseas voters are necessarily carrying these documents with them everywhere they go, and presenting copies of these IDs is no more burdensome than the process of actually sitting down, requesting, and voting an Article 21A ballot.
Ms. Shelton, on that issue, is there a grouping, and I know it's been in the briefing, is the petitioner challenging military overseas voters, or is he looking at those differently than overseas non-military voters? Because, you know, understanding the premise of what the federal statute allows for, you know, accounts for some of those burdens, but someone who chooses to live, you know, in Sweden and work for a private company, you know, they're not having to worry about walking across, you know, the desert to get to a post office. So what is the petitioner's challenge? Is it to everybody, or is he looking at military different than, you know, citizens that are abroad?
So our challenge on the overseas no ID does apply also to military voters. Our challenge is mostly only, I think the largest part of those challenges are overseas voters, not military voters. But to be candid, like the argument does apply to both sets. Anyone casting a ballot under Article 21A, just like anyone else voting in the state, has to present photo ID.
And is there an equal protection argument that is being alleged as it pertains to the fact that someone who's in Sweden working doesn't have to provide an ID versus someone who's here in the United States that has, you know, or here in North Carolina that has to go to the ballot and provide ID? Is there an equal protection argument there?
There's an equal protection argument in the sense of we should use the Constitution to help us understand what the General Assembly intended. We don't want to interpret the statutes in a way that in a later case, they would clearly be unconstitutional, because it would be irrational for the General Assembly to exempt the overseas voters. The overseas voters have almost virtually no checks and verifications that they are who they say they are when they vote. Even though,
Well, they do sign a declaration. There's a declaration.
That's right. There's their own say-so, which is really the only.
Well, I mean, a declaration is more than just say-so. I mean, it's given under penalty of perjury, is it not?
I agree with
Much like an oath and affidavit in North Carolina. It's just that in order to try and have some consistency across state laws and federal laws governing elections and governing overseas and you know, military members that come from all 50 states on a base having a consistent way of voting. Isn't that why Article 21A was enacted, to provide a level of consistency for overseas voters, including using declarations rather than affidavits, because declarations are more universally accepted across the state and in federal law.
If I may respond, Your Honor, I see I've got the red light on.
Well, I'm sure. Well, we've had lots of questions, and I'm sure Judge Tyson will give you some leeway on rebuttal.
Yes.
I mean, if I can respond to the pending question,
Please.
then I'll turn it over to that, please.
Please proceed.
So for the declarations, to be clear, like we would never allow just a declaration from any voter in North Carolina who's voting, a civilian voter voting domestically. We require far more. Our General Assembly has been, over the last about 15 years now, increasing election integrity measures in North Carolina. And I think it's rational to assume they intended to do so for all types of voters. Even as Justice Dietz noted in the prohibition proceedings, it is just too easy to commit voter fraud abroad. That's why we should not assume that the General Assembly would have intended to make it that easy to commit voter fraud. And when it comes to federal law, I also want to be clear, federal law doesn't have anything to say about this, because UMOVA Article 21A applies to state elections. The federal law only governs federal elections. And of course, this was an election for a state office. I don't want to abuse how much time you've already given me. So I'm happy to turn it over to the appellees unless there are any other questions from your honors.
I have one quick question. Do the statutes allow for an exemption of voter ID, a form that you can offer a reasonable excuse for not having an ID?
Absolutely, Your Honor. I don't have the citation at hand, but it's the same form for absentee voters. Or it's the same type of exemption scheme applies for in-person and absentee voters.
So there is a remedy in the statute if you do not have or cannot furnish an ID for identification. There's a remedy that you can still vote without having that, correct?
Absolutely, Your Honor.
Okay, thank you.
I have one more quick question too, and I appreciate you bearing with us here. The 2018 constitutional amendment for adding the voter ID requirement to our Constitution only applies to in-person voting.
That's correct, Your Honor. We have not relied on that.
No,
provision.
but so then my question is, then how, if that is a concern, how does that constitutional provision suggest in any way that our General Assembly was then concerned with overseas voters showing ID?
Because at the same time, or perhaps right afterwards, the General Assembly then passes the statute amending Article 20 to require photo ID for absentee voters. That's why we're not relying on the Constitution for this argument. It's just
and Article 21A was already in place when they amended Article 20 in 2019. So the General Assembly was aware of the existence of Article 21A and made no revisions in that statute law specifically to Article 21A, did they?
That's correct. So the General Assembly has generally treated Article 20 as where the general rules are for absentee voting. There are then special rules in Article 21A, but when the special rules don't contradict what's in Article 20, then Article 20 applies. And like I've said earlier, friends on the other side really haven't disputed many of the examples that we've given where there are provisions that say this section or this article in Article 20, but we know they necessarily apply to ballots cast under Article 21A as well.
Okay, thank you. We will try to give you a few minutes for rebuttal.
Thank you, Your Honor.
And we'll hear from the appellee. Gentlemen, which one of you are going to go first?
Your Honor, I'm going to proceed first.
Thank you. Would introduce yourself again, if you would, please.
Absolutely. Good morning, Your Honors, and may it please the court. My name is Nick Broad. I'm in the North Carolina Department of Justice, appearing on behalf of the State Board. I'm going to argue for the first 15 minutes, and then I'll turn it over to counsel for Justice Riggs. This court should reject petitioner's destabilizing request to cancel the votes of more than 60,000 innocent voters who did everything they were asked to cast a ballot in the November 2024 general election. Petitioner's protests fail for three threshold reasons, and that's where I'm going to focus my comments this morning. First, it is far too late to change the rules of an election that ended more than 4 months ago, and doing so would violate our state Supreme Court's decision in Pender County. Second, Supreme Court precedent dating back more than a century confirms that it would be fundamentally unfair to cancel votes based on errors allegedly made by election officials. And third, petitioners failed to properly serve the protests here. I'm going to start with the Pender County issue, and I think it's just common sense that we should not be trying to change the rules of an election 4 months after it ended. As Judge Hampson indicated in some of his questions to my friend on the other side, these rules have been in place for a long time, and there was plenty of opportunity to bring challenges to these rules well in advance of the November 2024 general election. Take, for example, the inherited residence statute that's being challenged. The General Assembly unanimously passed that statute in 2011, more than a decade ago. It's been enforced in over 40 elections since that time. The photo ID rule for military and overseas voters, that rule has been enforced in 5 elections prior to the November 2024 general election. It was approved by the Rules Review Commission. There was an open notice and comment process for anyone to come forward with concerns about the rule. The registration issue. A voter raised an issue about the registration form in October 2023. The board issued a written decision about how it was going to handle that issue in December 2023. Anyone could have brought a challenge at that time. And in fact, a group of plaintiffs did bring litigation concerning the registration issue. That litigation is pending in federal district court seeking a prospective remedy, a remedy to fix the issue for future elections. And I think that that proves up what seems to me to be one of the fundamental problems with the arguments on the other side of this case, is that the arguments on the other side of this case are asking for a retrospective remedy. And Pender County doesn't allow for that. Pender County instructs courts to, quote, minimize disruption to election rules. And
Counsel, then I guess my question then would be the same question I asked Mr. Shelton or your folks on the other side. How do you balance Pender County with James? And how do you reconcile the two of them with competing outcomes?
I'm going to echo a lot of Judge Hampson's questions to my friend on the other side when it comes to James, because I think I largely agree with his reading of that case. James, I think, is actually a pretty good case for me because the facts of James could not be more different from the facts of this case. What the board did in James by counting out of precinct provisional ballots was a complete shock and surprise to everyone. It even violated the board's own rules at the time. That's completely different from this case. All of the rules that are being challenged here were well known far in advance of the November 2024 general election. And so I think James stands for the general rule that if at all possible, if you have a challenge to a longstanding election rule, you should bring that challenge very promptly before the election. But if it's not possible for you to do that, Pender County, Purcel, that is not a bar. So if something happens that is a surprise, something comes out of the blue about the way that an election is being conducted, there is no Pender County bar, there is no Purcell bar, and that's James.
So is your contention is that notice is the divergent line between the two? And so I guess the question is, what if something, you're saying if something happens where there was no way to have notice, then that falls within James. But if there is notice, then that's Pender or Purcell.
Yes, exactly. That's our position. And I think that's the way to square the Purcell Pender County cases with our state Supreme Court's decision in James.
Question is, how can you challenge an illegal vote until an assertedly illegal vote until it's cast?
You absolutely can challenge those kinds of votes after the election under the election protest statutes. I have no quarrel with that.
So if the petitioner's challenge is to voters and not procedures, Purcell or Pender County would not apply. Do you agree with that?
I do agree with that, Your Honor. And I think that's an important distinction and an important way of looking at this case is that we're not talking about individualized challenges to specific voters. The arguments here are not that, there was a non-citizen who voted or someone under 18 who voted or someone who voted twice. That's not what we're talking about here. And in fact, the petitioner brought 3 other categories of protests that are not before you this morning because they did not seek judicial review of those protests that fall into that kind of category, and I think are a very useful contrast with the type of protests that are an issue here.
Isn't it true that the board, your client voted unanimously to bring these 3 protests before the board, the state board, as opposed to the county boards, to get a uniform interpretation? That was unanimous vote by the state board, right?
Yes.
And those 3 categories are what's before us today.
That's correct.
So that was the state board's decision. That they could have left it with the individual county boards, correct?
That's correct, Your Honor. I think.
And protests were filed in each of the counties.
That's correct.
So there was a concern about consistency.
Yes. I mean, one of the reasons that the board identified for taking jurisdiction over the 3 categories of protests here was uniformity and consistency. I think my modest point in raising the 3 other categories of protests is that those types of protests are to individual voters. They're individualized challenges rather than to the procedures that the board used, these long-standing rules. And I think when you're talking about challenges to, for example, someone who voted twice or someone who's a non-citizen, that's what the election protest statutes are all about. I have no quarrel with the ability to challenge those types of votes after they've been cast, after the election is over. But
let me ask you this. After the Help America vote was adopted federally in 2002, and then the General Assembly adopted a statute requiring either a driver's license or social security number or in the absence of either, a voter could still vote by requesting a unique identifier number, correct?
That's correct.
How can you explain, or what explanation is there for the board not complying with that statute?
Your Honor, I would point you to an attachment to an affidavit that we submitted in the Superior Court. This is at Document Exhibit Volume 2. It starts at page 224, and it has, I think, a chart that you might find helpful that shows all of the different changes to the registration form over time. And it was not until 2013 when there was an ambiguity that was introduced into the form that could possibly have been read to suggest that providing a driver's license number or social security number was not required. And this came to the board's attention as the result of a voter complaint in October 2023. When it came to the board's attention, the board issued a thorough written order that's also in the record in December 2023 that fixed the form, but then held that no further remedy was necessary. And as I said, there's pending litigation in federal district court, seeking a potential remedy for any concerns that might be implicated by the form for future elections. But of course, here we're talking about a retrospective remedy, and that is one of the fundamental concerns, I think, the fundamental problems that my friends on the other side face, which is that they're trying to change the rules of an election after it's over, and I think Pender County doesn't allow them to do that. I think.
Let me ask you this: does the board have the authority to adopt a procedure that is contrary to the express mandate of the statute?
No.
And that's what James says, correct?
I think you can read James that way, yes.
And doesn't James also say that if a voter relied on board guidance that is contrary to the statute, that still is not a reason to excuse the noncompliance?
I don't think so, Your Honor. I mean, I think from the voters' perspective in James, there's a big difference between the voters here and the voters in James. So the voters in James, they voted provisionally. So they knew that their vote was potentially subject to challenge when they cast their ballot. And the voters here had no idea. They had no idea that they were potentially going to be challenged.
Part of the class of voters here are identifiable as either absentee or provisional votes, right? We're
Yes.
not talking about any unchallenged votes on election day. We're talking about those that are identifiable either by being an absentee ballot or by being a challenge ballot for some deficiency.
My understanding is that with respect to the military and overseas voters, that's sort of one category of individuals who voted, and then the registration challenge is limited to absentee or early voting. But I don't think that changes the fact that from the voters' perspective, and I do think it's critical to look at these issues from the voters' perspective. From the voters' perspective, they did everything that they were asked to do in order to cast a ballot. I mean, the military and overseas voters, for example, they were told you don't need to submit a photo ID. And if they had been told to submit a photo ID, they would have submitted that information.
Isn't that the same thing the voters in James were told by the board, that they could vote out of precinct?
No, I don't think so. I think the voters in James were differently situated because they were told you are voting provisionally. Your vote could be challenged because you are voting in the wrong precinct. And that seems to me to be a very, very important difference here, because there is Supreme Court precedent going back to 1897. This is the Supreme Court's decision in State against Lattimore that holds that you cannot cancel the ballot of an innocent voter because of an error that an election official made. And it's not just the Lattimore case. Like, Lattimore is not just a random 1890s decision. I mean, Lattimore is on top of a mountain of state Supreme Court precedent that says over and over again that it would be fundamentally unfair to punish voters for errors that election officials make. I mean, this is Gibson in 1913, it's Woodall in 1918, it's Owens in 1948, it's Overton in 1960. I mean, Lattimore and this entire line of cases stands for the proposition that the remedy on the other side of this case is not the kind of remedy that's available under longstanding interpretations of our state constitution and our state election laws. Because again, you have to look at this from the perspective of the voter. You have to put yourself in the voter's shoes.
But the Supreme Court did disallow over 11,000 votes in James of voters who had followed the board's advice. But notwithstanding that, those 11,000 votes were disallowed.
I'll say two things in response to that, Your Honor. I mean, first, I don't see anything in the Supreme Court's actual written decision in James that said that the votes had to be canceled. I mean, the Supreme Court just remanded, and the election protest statutes give the board a range of different options in thinking through a remedy based on an alleged error of election law. And so I don't think it was necessarily.
And one of those is an ability to cure. Is that correct?
I'm not sure that I see anything expressly in the election protest statute that talks specifically about a cure process. I know that that's been a remedy that the petitioner here sought at an earlier stage of these proceedings. I do, before my time expires, I do want to just briefly mention service. And I want to make sure
prior to service, I'll ask Judge Tyson to give you a chance to discuss service. But I do have one question as it pertains to part of the contested number. The folks that have matching errors on their identification numbers. Is it your contention today that that has been fixed? So regardless of the outcome, I know you're talking prospective as far as fixed. Is it your contention today that, or let me just ask, are those matching errors still existing as it stands right now, that we still have matching errors on voters' ID and the errors still exist right now?
Well, matching errors can happen, and the General Assembly set out a process for how to deal with things when there's a matching error.
I understand that they can happen.
Right.
My question is, based upon the briefing, are there matching errors that exist as we sit here right now with voters' information?
Yes. I mean, there are data fields in the board's database that do not contain a driver's license or a social security number as a result of a matching error.
What are we supposed to do with that sitting as a review, as an appellate court?
Your Honor, I think what I would say is I would point you back to the Lattimore line of cases that I was discussing earlier, which is that at most that shows an error by election officials. It doesn't show an error by the voter. And in order to get the remedy that the petitioners are seeking here, you would have to hold that voters should be held responsible for an error that election officials made.
I don't think that's a remedy that we would look at, holding the voters accountable, because I'm troubled that we're at 2025 and we still have, voter identification errors sitting in our state, registry. And so I'm troubled by that. So and the fact that we haven't been able to get it right up until this point, I see why we have this challenge, to a certain degree. And I'm not talking about the entire that. I'm talking about the fact that there are a certain number of ballots and voters who don't have proper identification sitting in our registry is troubling to me.
Your Honor, I appreciate that concern, and I guess I'll say two things in response. I mean, first, as I mentioned, there is pending litigation in federal district court over this issue that's seeking to get a remedy for it on a prospective basis. And I think the second thing I would say is, the general statutes expressly contemplate that there may be matching errors, and anytime there's a matching error, the voters are required to prove their identity consistent with the text of the general statutes, and that's 163-166.12 in particular that provide for that process. And I think that's the best answer that I have for you.
Is it also not true, though, that certainly as it relates to the 2024 general election, with these challenged voters with the allegedly incomplete registrations, that they would have in fact been required to show affirmative identification in order to cast their absentee ballots under the provisions of Article 20A or 20, Article 20. In any event, so there was verification of their identification and eligibility to vote.
That's correct.
Thank you.
One last question. Do you agree that the voter's status on being able to vote is determined as of election day, November 5th? Is
Yes.
that the operative date to determine the eligibility of a voter to vote?
Yes.
So if an absentee ballot was cast early, that later that voter was not eligible to vote, that vote should be discarded. Is that correct?
That's true. I mean, you see this sometimes, for example, with voters who cast an early ballot but then pass away before the election.
Or move?
I would have to look at the facts of any particular case about the movement, but
Or become a felon between the vote and they're a felon on election day.
that's my understanding. Yes.
Those are no longer, quote, registered voters under the statute.
Any voter who is ineligible under the Constitution or the statutes should not be allowed to cast a ballot and have it counted.
Thank you.
I'd ask to give him time to address this. So I think Ms. Brooke wanted to address the notice for service.
Okay, we'll briefly.
Yes, I'll very briefly, because I don't want to eat into any more of Mr. Bennett's time. I know there's a lot of briefing.
We'll give Mr. Bennett his full time. Thank you.
Thank you. I know there's a lot of briefing before the court, and I just want to make sure this doesn't get lost in the briefing, which is page 49 of our brief. Page 49, yeah, it's a lot, I know. Page 49 of our brief has a copy of the postcard that petitioner sent to the affected voters, and I would commend looking very carefully at that postcard. It does not give adequate notice to the voters consistent with the board's service rules. The board service rules say that petitioner had to serve copies of the protest filings on the affected voters, and all the voters got was a postcard with a QR code. There are a lot of people.
How do you respond to petitioner's argument that the board did the very same thing? They mailed out a postcard with a QR code on it.
Well, Your Honor, those were not legal notices. Those were not legal notices that initiated a legal proceeding under a statute. And
how do you respond to the statute that requires the board to provide notice and not the petitioner?
Well, that's true at the hearing stage, but we're at the preliminary consideration stage, and I think.
Is there any requirement in the statute to provide notice at the preliminary stage at all?
I think the statute authorizes the board to promulgate rules for adequate notice, and I point you in particular to section 163-18210E as an elephant. And I think that is the statutory hook for the service rules here. I do just want to get back to the QR code issue and just say briefly that there are a lot of people who don't have cell phones. There are a lot of people who don't know how to use a QR code. And even if they were able to use the QR code, the website that it would take you to was, complete with hundreds of different types of protests that a voter would then have to sift through to figure out whether their vote was actually being challenged. The QR code on the postcard image in our brief still works. And so I would commend it to the court. If you hold your phone up to that QR code, you can go put yourself in the voter's shoes and see what they would have had to have done to figure out whether their names were at issue here. And I think looking at the postcard will show that it did not comply with the board's service rules. And for all those reasons, we'd ask that the court affirm. Thank you.
Thank you. Okay. Thank you. Here are additional arguments from counsel from Justice Riggs.
Good morning, Your Honors, and may it please the court, and thank you, Judge Tyson, for your indulgence in giving us our full time. I'm Ray Bennett, and I'm appearing here today on behalf of Justice Riggs. For more than 200 years, elections have proceeded in this country under a principle so basic that it is known on every elementary school playground. You cannot change the rules after the game has been played. If you lose, you accept defeat graciously. If you do not like the rules, you argue about them before the next time you play. Judge Griffin's protests in this case run afoul of that basic principle of common sense and of election law, and they were properly rejected because they pose a risk to the stability and integrity of our elections in North Carolina. My friend Mr. Broad and Justice Dietz have ably explained why this principle squarely applies under North Carolina law. This principle is also clearly enshrined under federal law, as are several other constitutional and statutory issues that are presented here. As this court is aware, this matter is being heard on remand from the federal court, which has abstained but reserved jurisdiction over the federal law issues in this case. Therefore, I need to begin just by making clear that everything I say here is subject to the England notice we filed with the Superior Court, included in the record at pages 146 to 149, and restated in our brief at pages 14 to 15. We've informed the court of our federal law arguments so that North Carolina law may be construed in light of those arguments. And Justice Riggs has stated clearly on the record, as she must protect her rights, that if the state courts rule against her on questions of state law, she will return to federal court for the disposition of her federal contentions. That said, we have no desire to return to federal court if we do not have to, and this court is not powerless to put an end to these protests by rejecting them under state law. This court can and should bring an end to this election more than 4 months after North Carolina voters went to the polls and decided this race by 734 votes. It does not have to drag on for months to come. Now, there are two state law threshold grounds on which every one of Judge Griffin's protests fails that have already been addressed by my colleague, Mr. Broad. And so I'll rely on the papers and on his arguments, both for the Pender County argument that you can't change the rules after the election is over, underscored by other decisions like Lattimore, Woodall, and James C. Bartlett itself. And also that Judge Griffin failed to provide voters adequate notice that their constitutional rights were being threatened in accordance with state regulations that were in place and adopted unanimously by the board and approved by the Rules Regulation Commission. But even if you disagree with us on those two threshold points, as the board explained in a lengthy, meticulous decision, every one of Judge Griffin's protests also fails on the merits under state law. So to begin with the UOCAVA voters, these are the voters that voted overseas and respond to Judge Gore's question. These are military voters, their spouses and family, and other overseas voters. A quintessential example would be a military spouse living overseas where her husband is serving in the military. That spouse votes absentee using an absentee ballot regime that's specially created for these voters to make it easier to vote and address the unique challenges that confront our military when voting. In fact, our country has a long history of intentional efforts to try to make it more difficult on members of the military to vote. And the federal government sought to correct some of those abuses starting in the 80s with the statute called UOCAVA and created specific federal forms, both for asking for an application and for voting, that can be used in federal elections. And in 2011, our General Assembly decided unanimously to adopt UMOVA, which is found in Article 21A, which allows military, family, and overseas voters to vote according to the rules that apply in federal elections. Now, these two regimes are completely different, are substantially different, and found in two different sections of our statutes. Article 20 governs absentee votes for domestic voters, and then Article 21A governs absentee votes for military and overseas voters. I've heard a number of policy arguments from the other side about why they think that some of the provisions from Article 20 should apply in Article 21A, but that's simply not how statutory interpretation works. Article 20 was amended specifically by the General Assembly to require in Section 163-230.1 F1 to make it clear that voters voting under this section must provide voter ID. That's a provision that was amended in Article 20. A parallel provision was not added to Article 21A. Now, there are policy arguments that have been made by the other side as to why there should be voter ID required, and of course, those can be made to the General Assembly and may be made at some point, but there are equally good policy arguments that apply for not requiring and explain why the General Assembly would not have imposed those requirements. Indeed, not only is there out of the some 35 states that require voter ID across the country, none of them require voter ID from the UOCAVA voters. There are federal instructions that are provided by the federal government that explain state by state what requirements apply to military voters. And including all those 30 plus states that have voter ID, not one of them requires voter ID from their military and overseas voters. So what my friends on the other side are seeking to do is to impose a requirement for this state, for this election, that's not been applied to any military and overseas voters across the country. And indeed, when a rule that was promulgated by a bipartisan board unanimously, then approved by the Rules Review Commission unanimously, without any objection from anyone, including the Republican Party, even though there were comments that were given to other aspects of those regulations. No challenge to this rule that was promulgated to confirm that there is no requirement for these voters to provide voter ID under Article 21A.
Judge Gore asked earlier if there's a difference between a military voter and just someone who happens to be overseas, and how the person overseas can vote without a ID on equal protection when we require that for people who are voting here. Can you address it?
Yes, sir. Thank you for that question. And I think ultimately those are policy arguments. They are questions to be asked, but the federal government, in applying a regime to UOCAVA voters, decided that UOCAVA voters would include not only military families and their spouses, but also voters who vote overseas. So this entire regime from the beginning has applied to all voters that are voting from overseas. Now, that I think the policy arguments underlying that that have been made both for military and others are, if you're a missionary family somewhere that may not have as good access to technology, this regime has been applied to those voters as well. Now, I hear the argument about why somebody who's in Sweden and working in a large city might be able to provide a voter ID. Again, those are arguments that could be considered by the General Assembly in trying to balance this tension between addressing the concerns of military and overseas voters. And
there's also a reasonable excuse form in the statute that allows a voter without an ID to offer one of 9 reasons, correct?
Yes, Your Honor, that's correct.
Was that form furnished in the absence of an ID?
Well, no, so that form is not furnished to Article 21A voters. And one thing to make clear about this is that the vast majority of Article 21A voters actually don't vote by paper. They vote by an electronic portal where someone who's in whether a submarine or a battlefield or anywhere else in the world can log online and vote by internet. We don't allow that for any of our absentee voters here in the United States. They are provided with, they have to request their ballots more than a week before the election day. They receive paperwork. They get a container return envelope that has to be signed by 2 witnesses or by a notary. The whole regime, the requirements for these Article 20 voters is completely different and distinct. And so if you log into that portal, you're not provided with an opportunity to provide a photo ID or to provide an exception. Now, again, there may be policy arguments for where the General Assembly might consider in the future to apply a photo ID requirement to those voters. But as you heard my friend on the other side concede, there is the Constitution only applies the voter ID requirement to persons who vote in person. So it's ultimately up to the General Assembly to consider those policy trade-offs. And they made a decision several years after voter ID went in place for in-person voting to require it for absentee voting for domestic voters under Article 20. But they specifically said that it applies in this section. They did not apply it to Article 21A. And the best my friends on the other side can come up with is kind of an inference of, well, surely these additional requirements that Article 20 must apply under Article 21A. And the reality is that Article 21A specifically gives the state board 163-258.4D, the state board shall develop standardized absentee voting materials, including privacy and transmission envelopes and their electronic equivalents, authentication materials, and voting instructions to be used with the military overseas ballot of a voter authorized to vote in any jurisdiction of the state, and to the extent reasonably possible, shall do so in coordination with other states. So the board has the authority to promulgate regulations and in good rulemaking fashion, in some respects, does line up some of those things with what the requirements are in Article 20. But to the extent that there's direction from the General Assembly about what should apply in Article 21A, the gap filling, it doesn't direct the board to Article 20. It actually directs the board to consider what's being done in other states. So coordination with other states here is 49 other states that don't require voter ID for this special category of voters.
I want to ask you about the folks, I guess the category is referred to as never resident.
Yes, sir.
And that's a subset, I guess, of overseas voters that have never resided here and have no intent to return. Can you address that?
Yes, sir. Gladly. Thank you for that question. Well, there's two things that I want to say, just as a threshold matter. Of course, the threshold challenges of notice and that changing this rule, which has been in place since 2011, was unanimously passed. It's been applied in 43 elections since that time. But the General Assembly made a decision, concluded that a particular very small group of North Carolinians are residents. Now, this group, they are children of overseas North Carolinians. They may be on a military base. The most classic example would be a child who grew up moving from military base to military base, or a child of a family on the mission field that grows up with parents who are North Carolinians, and they turn 18. So that child then votes alongside their parents in North Carolina elections, just as their parents have done from overseas. Now,
Once they become emancipated, they must be 18 to vote.
Yes, sir.
And they're also an emancipated adult at 18.
That's correct.
Right. So
Yes.
why would they continue to inherently have the same residence as their parents when they're an emancipated adult?
Okay, so great question. The answer to that is, so residence under North Carolina law, well-settled North Carolina law, means domicile. When one is born, you inherit the domicile of your parents. The other friends on the other side have suggested, well, there's no reason to think that that person keeps that domicile when they turn 18, but they can't sign any law that says that that domicile changes. What I can cite is Owens against Chaplin, North Carolina Supreme Court from 1948, said it is well-settled principle that when once established, a domicile is never lost until a new one is acquired. It is well settled that to effect a change of domicile, there must be an actual abandonment of the first domicile, coupled with an intention not to return to it. And there must be a domicile acquired by actual residence in another place and within another jurisdiction, coupled with the intention of making the last acquired residence a permanent home. So if you have a child who inherited a residence, turns 18, the law is that they maintain that residence until they decide and make clear, I've chosen this military base, this mission field, this location overseas as my permanent home. Until that happens, they remain residents of North Carolina.
Even though they have no intent to return.
No, it doesn't. Just to be clear, the box that these individuals checked is that they live outside the United States and have never lived in North Carolina. That's not the same thing as I have never had a residence in North Carolina. And they are not saying that box number 4 in that form does not say I have no intention to return. It simply says I have never lived in North Carolina. These absolutely may be individuals who have every intention of coming back to North Carolina for college. They may, and just because they haven't lived here doesn't mean they have never been here. The other side suggests these people never been to the state. They may have grandparents here. There's some of their good friends may be here. They may regularly come here. They may root for ACC basketball teams. They may feel more connection to this state than they do to whatever country that their family has chosen to serve in some way overseas. The last point I just want to make about this particular category, if you agree with us that the first 2 categories fail, there's simply not enough votes that were challenged by Judge Griffin. There are only 266 votes. And he's attempted to add some additional non-record evidence of additional voters that have been identified since the time of the protests. But those numbers do not, still don't come anywhere close to the 734 vote margin that's in effect in this case. And the suggestion that, oh, all I need to do is identify a potential issue, and then later down the road we can have some discovery and find some facts that might allow me to overturn an election. That's simply not how election protests work. This is not litigation. Our Supreme Court said in the Bouvier decision that swiftness is the order of the day in protest cases. So the whole idea is you need to come forward with your evidence, provide the information that would allow the board or a county board to decide quickly, not 2 things. 1, is this an irregularity? And 2, is it enough to impact the outcome of the election? And so this one by itself, 266 votes, is less than a third of the margin. This one can be dispensed with without even reaching the specific legal question that's presented here.
So staying on this general topic of these of the overseas voters and inherited residents, these definitions of covered voters are part of the Uniform Act that was adopted in Article 21A.
That's correct, Your Honor.
Given that it's a uniform act, are there other states that apply the same definition to overseas voters, allowing folks that are U.S. citizens with a right to vote, allowing states to claim residence over these voters?
That's a great question, Your Honor. I don't have a specific answer for you. I'd be glad to investigate that one. I assume so because it's a uniform act, but the argument that my friends on the other side are making here is that this is contrary to the North Carolina Constitution. And I think under North Carolina law, that particular provision, it's never been held that those individuals are not residents. They say, well, there's no case that says that they are. But I think it's absolutely consistent with North Carolina law and the principles of domicile of origin that those individuals are residents. And to whatever extent there was any ambiguity about that, then the General Assembly has the ability by statute, and again, unanimously, not a single nay vote in the General Assembly, to say that these people are residents. And there's nothing in the Constitution that suggests that they are not. If I may briefly address the HAVA and the driver's license Social Security issue. This.
I know, I see. Went proceed.
Thank you, Your Honor. This is an issue that Justice Dietz described as almost certainly meritless when this was up in front of the Supreme Court. And that I think is absolutely right. So more than 60,000 voters from across the state. A quintessential example of a voter will be somebody who's been voting in North Carolina elections for years, sometimes decades. Every time that they've gone into to get their vote, someone has pulled open the book. There's been a sticker with their name on it. They have put it on their ballot. They voted. They've walked out. There's been no question about their vote. The exact same thing happened to them in this election. No one raised any issue about their vote before the election. Now,
whose responsibility is it to maintain the accuracy of the voter registration list?
That's ultimately the responsibility of the state board. It is not the responsibility of the voter. Now, there are several things just in terms of
who has the responsibility to prove their eligibility to vote?
The eligibility to vote is something that is subject to challenge, and then if the voter's notified about it, they would need to come forward and prove that they are in fact correctly voted. The others are also able to present information.
So it is or is not the voter who is ultimately responsible for proving their eligibility to vote?
Well, I want to make a distinction here between eligibility and registration. There are certain things that make one eligible to vote. In our Constitution, Article 6, Section 1 talks about who may vote. It's people who are qualified to vote under the law. Those issues turn on: are you a U.S. citizen? Are you 18? Are you a felon that's currently under a sentence? All those are in Article 6, Section 2. There are qualifications to vote. Those are always appropriate grounds to bring a protest, and those were brought as part of this case. They ultimately were unsuccessful, but there are those sorts of challenges may be brought. But that's eligibility, which is different from registration. Our Constitution and a statute do require that a voter be registered, but registered to vote, every single one of these voters was registered. They were registered, they were on the books, they were on the voter rolls, and we do, as your honors likely know, there is list maintenance in between elections under federal law, under the NVRA, and again, we're not relying on anything under federal law here, but in the last 90 days before election, everything goes pencils down. You can't scrub the registration records in the last 90 days, precisely to avoid the kind of mischief that can result if people start trying to say, oh, well, these people shouldn't be registered and others should be. But you can still challenge somebody who's not eligible in those limited categories. But that does not throw wide the door for anyone to come along and say, let me look very carefully at the minutia of the registration laws and see whether any of those had issues before you got on the books. And that's that whole line of cases that Mr. Brode referred to that are well established in North Carolina that with respect to registration.
In order to be eligible to vote, must you also be registered to vote?
No, sir. That is not a qualification to vote. One must be on the registration rolls. You must be registered in order to vote. Every single one of these people was registered. So the argument has to be they were not properly registered. The other side would say, well, there was an issue along the way to when they became a registered voter, but there's no dispute these individuals were registered to vote. And if I might just quote from that Lattimore case that Mr. Brode referred to, it says, a vote received and deposited by the judges of election is presumed to be a legal vote, although the voter may not have complied with the requirements of the registration law. And it then devolves upon the party contesting to show that it was an illegal vote. And this cannot be shown by showing that the registration law had not been complied with. But if the party is allowed to vote and his vote is received and deposited, the vote will not be afterwards held to be illegal if he is otherwise qualified to vote, 18, U.S. citizen, and so on. And where a voter has registered, but the registration books show that he had not complied with all the minutia of the registration law, his vote will not be rejected. Now, that lines up to answer a question from Judge Core from earlier about that matching issue. You'll see from that affidavit from the board that was filed in the Superior Court, there's something like half of these voters had a matching issue with their data. Now, to be clear, when we're saying matching issue, this is just any number of potential data errors. This could be somebody's maiden name that changed. It can be a hyphen. Any number of, this is like, that affidavit kind of lays out some of the facts about how you have to have a precise, exact match in order for that match not to fail. When there isn't a match, that data falls out of the state board's data field. So you will have a blank, even though you provided your social security number or driver's license.
And
now,
is it the board's responsibility to secure whatever's needed in order for them to verify the accuracy of the vote?
No, Your Honor. Actually, by statute, the statute says is very clear that if there's a data, if this possibility is contemplated, and in 163-166.12D, it actually says that if there's not a match, that shall not prevent that individual from registering to vote and having that individual vote counted. So by statute, even if you don't have a match, you can't be prevented from registering and you can't be prevented from voting. That's the General Assembly talking there. Now, I think it's important to understand this particular issue, that their HAVA is a federal law. They're saying that that's not an issue here. Take that for what it's worth for the moment. And they're saying only state law applies. Now, state law was amended when HAVA was passed in order to request that information on the state form because it was necessary in order to comply with federal law. But I think it's important to note that 163-82.4A11 says state law, the form must request, it does not say require, a whole long list of information, including the applicant's name, date of birth, county of residence, date of application. And by their logic, that would mean that if somebody doesn't put the date of application on their form, if everything in that list is required, that means the next election that we could have somebody coming back and saying, well, let's challenge all the votes that didn't include the date of application on the election because the board didn't go out and require that information from those voters.
I'll give you a moment to sum up.
Yep, thank you, Your Honor. To conclude, it is time for this election to come to an end and for voters to know that their votes will count in this state if they follow the rules in place at the time of the election. The state courts have the ability to provide that certainty and to strengthen the integrity of our elections by rejecting Judge Griffin's protests on the merits under state law. Thank you. If the court has no further questions, thank you.
Thank you, sir. Rebuttal?
Thank you, Your
Mr. Clerk, will you set the clock to provide for rebuttal? You may proceed.
Thank you, Your Honor. For the England reservation, I want to emphasize that this court has jurisdiction over the federal issues in this case, not just the state issues. The England reservation here was ineffective and is always ineffective if a party actually litigates the federal issues in state court. And that actually happened here repeatedly. The appellees litigated and had the federal issues actually decided in the state board proceeding. The board itself adjudicated the federal issues. The appellees then litigated the federal issues in the prohibition proceeding in the Supreme Court. The appellees then litigated the federal issues in their briefs to the Superior Court. And that's why we're asking this court to first expressly decide that has jurisdiction to rule in the federal issues, and then to actually resolve all the federal issues. Judge Tyson, you asked earlier whether the never resident protest was a facial or an as-applied challenge. We think it's primarily a question about statutory interpretation. We framed it as an issue of constitutional avoidance, and constitutional avoidance arguments don't go to 3-judge panels. Mr. Bennett also argued about the validity of a voter's registration, and he said that a voter registration can't be challenged through an election protest. That's not correct. Bouvier expressly rejected that argument. The Supreme Court held that an election protest can challenge whether a voter was, quote, legally registered to vote. That's our argument. On Purcel, their argument can't be reconciled with the protest statutes. Under their interpretation, if the state board announces before an election that it's going to let felons vote and no one challenges that before an election, then no one can file a protest seeking to enforce the law after the election. Under a rule like that, the state board is the one that actually gets to make the law, not the legislature. But the legislature didn't intend to permit anything like that kind of lawlessness. Judge Tyson, you also asked earlier about the residency cutoff for voting. By statute, section 163-55A, a person has to have resided in the state for at least 30 days preceding an election to vote. That statute applies to all voters. Mr. Brode argued that under James, there was no order for the discounting of ballots. We can just read what James said. It said, the Supreme Court unanimously said, we cannot allow our reluctance to order the discounting of ballots to cause us to shrink from our responsibility to say what the law is. And the court then said it was without power to rectify the board's unilateral decision to instruct voters to violate the law. Those are my points that I wanted to make on rebuttal, Your Honor, because you guys have been really generous with the time, but I'm also here to answer any other questions that the panel has.
So what remedy is the petitioner looking for here?
The remedy we're seeking
If
is-
we agree that you're not procedurally barred.
Yes, the remedy we're seeking is the discounting of ballots because that's the James remedy, and we believe that that's the binding precedent. That's very straightforward for the never residents. You need a remand on the never residents to figure out how many never residents there were, and to discount those ballots. For the overseas no ID folks, that's a certain number. Everyone knows.
How do you respond to the argument that if we agree with you, that still would not change the outcome of the election?
So on the never residents, I'd say two things. First, if some of the other ones proceed, you agree with me on the merits of any of the other protests, then you can consider the never residents as well. But just as importantly, we never got to the point where we had to identify any voters who are actual never residents. At the preliminary consideration stage, there's no requirement that you actually identify the voter. You have the legal theory. And under Godfrey, in fact, the board never ruled on this outcome determinative argument, this new argument that we're hearing on appeal. So that's actually not an argument that's properly before this court, whether it was or wasn't outcome determinative. But even on the merits, we simply never got there. In this case, we had and the administrative record shows this, we had asked the board to subpoena the county boards so that we could find out how many never residents there are. We got data back from about 40 counties that show there are over 500 never residents. So there are 60 counties left. That includes some big counties like Mecklenburg County. So even if we were to look at the outcome determinative nature, we have shown that there is probable cause to believe that there are more than 700 never residents. There are only about 200 left, and we only need to show that exists in about 60 counties, and that includes big counties like Mecklenburg.
So you would ask the court, what is your plea before the court today?
So we'd ask for this court to order the discounting of illegally cast ballots. That includes determining how many people on remand had incomplete registrations. And therefore, we'd ask for this court to reverse the judgment below.
All right. Ethan. We would like to thank you for your good arguments. The case is submitted. Again, we appreciate your arguments, and we appreciate your answers to our questions. We hope you agree the court was generous to allow you to make complete arguments on all sides. So with
Very
that,
much so.
thank you.
Thank you, Your Honor.
Mr. Clerk, will you please adjourn court?
Yes, Your Honor. This session of the North Carolina Court of Appeals is adjourned.
Thank you.
Thank you, Your Honors, counsel.